So moving on to
Sure.
motions now. Okay, so motions is like a whole new big set of procedure in the rules. And so my question is like, let's say that you want to change the affidavit or the factum that you've already submitted in onto filed with the court. Are you allowed to do that?
Yes, you're allowed to do that. Similar to what we just talked about as
Okay.
amending. I mean, there's a few ways to do it, right? The thing that's important about motions when it comes to making changes
Yeah.
is your deadlines, right?
Okay. Right.
You have to have everything served 7 days or whatever it is before your motion date, so that the other side can serve theirs 4 days or whatever it is.
All right. Yeah, I
You can
remember.
look in the rules, and the rules will set out those dates.
Right.
Now, you got to be careful because there's different kinds of motions that are going to have different kinds of rules, and there's also practice directions for different courts that want things on different timelines. So you got to make sure
Okay.
you got to look at the rules for general motions. You got to look at any particular rules that relate to the motion you're bringing, and then you got
Mm.
to look if there's a court order. Sometimes a judge will say, "Well, bring your motion. Here's a timeline to bring your motion."
Oh, right, right. Okay, yeah.
Like, and I'll give you an example. So I do a lot of motions for leave to appeal in the divisional court, and
Hmm.
usually we'll get an outline, a timeline from a judge at a
Right,
pre-conference meeting
right,
saying this is when everyone needs to put
right,
in their materials, and those are your deadlines, right?
right.
You you can get them changed a little bit if your opposing counsel, agrees and stuff, but generally the rules the timelines you got to follow. So if you make a mistake that you want to change after your deadlines,
No.
you could try and you should try, but you might run into some problem, right?
Well, can't you just get like if it's a minor thing, but and you can just get a consent of the other side, and that would mean that it's
Yep,
probably easier for you to change?
absolutely. So
Yeah,
let's say you have an affidavit, you wrote an
yeah,
affidavit,
yeah.
and you forgot to attach a document that's important, right? Because an affidavit is
Yes.
sworn evidence,
Yeah,
and it also is uh, the document that brings other documents into the court, right? So
yeah.
if you want to talk about, on June 6th, Heather sent Dan an email saying 1, 2, 3, 4.
Mhm.
You would then, in your affidavit, you would say, on this date, I got an email from Dan, whatever. Here's a copy of the email as Exhibit A.
Mhm, mhm. Right.
If you forgot to do that when you
Yes.
did everything, you forgot to put that in, you might want to make an amended affidavit that
Yeah,
adds that in.
yeah.
If you said on June 6th, Dan sent Heather an email, but then for some reason you realize, no, it's July 6th,
Yeah,
or whatever it is, and
yeah.
that's wrong, you have an obligation to fix
Oh,
that because you can't lie
oh.
to a court, right? So you have to then go and amend your affidavit and say, oh, maybe provide an explanation for why, you got it wrong. Because,
Oh.
because this is your credibility is in your affidavit. It's you're telling the truth. If you're all over the place,
True. Yeah,
then that it doesn't help you, right? So you want to fix that, and you want to amend your affidavit.
right.
You would
And
do it
like,
in a similar way we just discussed for the pleadings, right?
yeah, and it's likely that the other side will probably let you because, like, why wouldn't they? Like, it's
No, that's not true. Other sides
no.
don't like to sometimes don't, especially for motions, they don't like to let you because
Oh,
if those timelines are up, motions sometimes are tight with time. So
mm,
if you're going to change something in your affidavit, the other side's got to then respond.
yeah.
And one of the tests that the court's going to look at when allowing someone to amend anything, because I touched on this just a tiny little bit, even for the pleadings, when you want to amend your pleadings, there's a legal concept called prejudice.
Mhm.
If your amendments are going to prejudice the other side, more so than it's going to help, the case run better, the court's not going to allow it. The court's not going to allow you to cause all this prejudice to fix a mistake you made, right?
Okay, so let me see if I get it straight. So let's say I want to make the amendment and the other side refuses, and we're talking about after the deadline, I suppose. Um, so then I would bring a motion to ask for the permission from the court to change whatever I need to change.
It depends on your motion. If it's a small motion with a tight deadline, it might not be worth your while to do that because you might not have time to do that. Your motion to actually hear the substance of your motion is probably close. You
Yeah.
might want to file just a supplementary affidavit that explains the problem and just
Oh,
file it and see what the judge wants to do with it.
oh, interesting. Oh, I see. Okay. Oh, that's interesting. That's a really good tip. Okay. Because I'm thinking in my head that if the other side objects, then you're doomed. um,
You might be doomed. Look, when it comes to motions, motions aren't I don't know how really to put this, but it's
yeah.
the judge is going to deal with the context of the motion, how
Mm.
important the motion is, what the motion's for, what the nature of the amendment is. They're going to look at it in context,
Okay.
and they're basically going to decide, how much prejudice is this going to cause? Why did you make the mistake? What's your explanation? If you're amending an affidavit, you're amending your sworn evidence.
Yeah.
So if you're just saying, "Oh, I made a mistake on the date of this email," I don't think any judge is going to spend a lot of time worrying about that. I don't think the other side of the lawyer on the other side is going to spend a lot of time worrying about that.
Right.
But if you change something like, "I saw Mr. Smith breaking into the house," and then you said, "Actually, I saw Mr. Jones breaking into the house,"
Yeah.
a day before the motion, the judge is going to, "What are you talking about?"
Whoa. Yeah.
And you have to explain why you swore
Yeah.
on as an affiant,
Right. Yeah. Wow.
that, and now it's wrong. So it's going to be really context specific because of the way sort of motions work.
That's
Uh,
interesting. But
uh,
yeah, you could try filing the supplemental affidavit.
Supplemental might just
And
be
we'll see.
easier
Yeah, and then we'll
with
see
an
what the judge thinks.
explanation. Sorry.
And then we'll see what the judge thinks, because like
Yeah,
you said, I mean, you're right, because likely this is going to be like a few days before the actual hearing itself anyway. So it's really,
it could
um,
be. It could be. I mean, it could be months.
it
It
depends.
really depends on everything, right?
Yeah,
That's happening. Some motions are, if you have a big summary judgment motion,
yeah,
those could
yeah,
be days. Those could take days to
yeah,
hear, and they're months. They're scheduled months out.
yeah.
If you have a motion for some a little thing, it could be, you have 15 minutes before an associate judge, and you're out the door, right? So
All right, one last thing before we close up today.
sure.
Just very quickly, if you can, you mentioned the word prejudice. I mean, that's very commonly used amongst the profession, but for someone new coming in or a layperson, when you say prejudice, what does that mean? Does that mean
So
harm? Like, what does that
it
mean?
means harm.
Harm. Okay.
Yeah, it means harm. I don't even really know what it means. It means harm, bother, cost, uh, delay. Well, not really delay. In some contexts, delay is considered prejudice, and in a lot of other
Oh,
contexts, it's not
interesting. Right.
considered prejudice. But basically, if uh, you have to go out of your way and do something you shouldn't have had to do, or is really going to throw a wrench in your plans and all that stuff, you can call that prejudice.
Oh, so very kind of like general, sort of like,
Yeah. So even if you look in the rules where it says, and I think this might even be under amending pleas, I don't have it in front of me,
yeah.
but it sometimes says prejudice that cannot be compensated with costs or some wording like that.
Yeah, I remember.
So, yeah. So they understand that, if someone's asking for something, even if it causes that other side prejudice, if they pay for that prejudice, it's okay. Right.
Yes.
So it's
Yeah.
usually just more work, more delay, that kind of thing. Or if you're getting, and that's in a civil litigation context,
Right.
sometimes it could mean, or sorry, that's more in the procedural context. Sometimes it could mean evidence that comes in
Right.
that is very prejudicial. That means it hurts the other side,
Right.
but maybe it's not. I don't know. There's some other reason why we'd have to weigh the prejudice of laying that evidence in, right? Or maybe I'm not being clear, but prejudice just means harm, and it's usually in procedural or in evidence entry contexts.
Okay, that's great, Dan. So, any last words? Because that's pretty much it for today. Yeah.
No, I
I
think
pass.
that's all. I just want to tell everyone, we're filming this video in early 2023. The
Mhm.
rules change all the time, so after you watch, go check the rules. The Civil Procedure and Practice in Ontario page on Canley is very helpful to help you understand the rules. And yeah, I mean, this isn't legal advice. This is just me talking generally. So don't do anything just by watching this video. Go check the rules first.
Well, thanks very much for coming in, Dan, and thanks very much for watching. If you're new to the channel, don't forget to hit the subscribe button, and we're going to see you at the next video. Thanks, bye.
Thanks.